I'll call the meeting to order. This is the June meeting of the Wilson County Board of Zoning Appeals. I apologize to everybody for being a few minutes late getting started, but we had a lot of people to get signed in and some last-minute paperwork we had to work through. So, again, appreciate everybody being here. We have an agenda that's been set and advertised. Does anybody here want to withdraw today or defer to a future meeting? And if not, the agenda will stand as published. Reminder to everyone, we have a court recorder here that's taking a record of our proceedings. If you'd like a record, transcript of a particular case, if you would please see the court recorder after we're concluded today. That would be at your expense, but she'll be glad to tell you how you can obtain a transcript. Just a reminder to everyone, if you would please silence your cell phones. As we go through the agenda, I'll call each case and read the request, and then we'll get staff recommendations. We'll ask the applicant, if you would please, to come to the podium first, give us your name and address, and then make any comments to the board you'd like to make. Then we have some others that would like to address the board, either in support of the application or in opposition. We'll want to hear you also, and if you would please come to the podium as soon as the applicant has had a chance to speak. So if you do plan to make a comment to the board, you need to be sworn in. So at this time, if you would please raise your right hand if you do intend to comment. Do you solemnly swear or affirm that the testimony that you're about to give before this board is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Another reminder, the staff has made recommendations to the board in regard to each case, and we will consider their recommendations as we render our decisions. The meeting this morning is being videoed by the county television service, and it will be available for viewing on YouTube. Wilson County TV is the channel, and you can watch that later if you desire. The state requires that before each public meeting, we have a public comment moment or section. And this is not in regard to any case particularly that's in front of the board. We'll give everyone a chance to speak to the particular cases as we go through the agenda. But this is a general comment period. If there's anyone here that wishes to comment to the board about anything other than what's on our agenda this morning, or any other comment you'd like to make, we'll hear that at this time. So anybody here wish to speak during the general public comment period? And seeing none, I'll close the general public comment. Turning to the members of the board, you were mailed the minutes of our May meeting earlier this month, and you've had a chance to review those. Do I hear any corrections to the minutes? And if not, if there are no corrections, do I hear a motion to approve the minutes from the month of May?
Motion to approve.
I have a motion to approve. I hear a second.
Second.
I have a motion and second. Any discussion on the motion? If not, all in favor vote aye. Aye. Opposition vote no, and the minutes are approved. Okay. Our first case is case 4254. It's been deferred from our February meeting and our April meeting. Jamie and Alice Duncan requesting to have 2 dwellings on 1 tract of land. Tax records show that there have been 2 dwellings on the property since 2014. A variance is needed for the side yard setback requirement of 20 feet for both the north and south property lines. One home appears to be right on the north side property line, and the other home appears to be right on the south side property line. A variance of easement width was approved by the board May the 22nd, 1998. The property is located at 5604B East Richmond Shop Road, Parcel 5, Wilson County Tax Map 135, consisting of 1.5 acres zoned A1 agricultural. To the staff, we've already had the public comment and hearing on this case, have we? Didn't we have that in February?
Yes, sir, we have.
Okay, so we'll get your recommendation, and then we'll go from there.
Do you want me to reiterate everything or just the update?
Just the update, if you would, please.
Okay. Staff has worked with the applicant and the applicant's surveyor in the last few months. Comments Day has had no contact within the last 30 days. They actually came into my office after I'd finalized comments yesterday to show me a plat exhibit, more or less. Her surveyor is not going to be able to get out there until July, she has stated, but that's not going to have any bearing on my recommendation. If this issue is going to be worked out, staff believes that this should be through platting and the planning commission. She has 2 lots that I believe can be amended and reworked to mitigate the variance request. So therefore, staff recommends the denial of the request for 2 homes on a single tract of land.
Okay. So we've already had our public hearing, and we deferred a decision until this information came back in. Mr. Jennings?
Yes, sir.
I don't, we've already had our public hearing. I'm of the opinion we don't need to open anything back up.
Has anything changed on the application at all?
No, sir. Nope.
That we open it.
Okay, good deal. All right, turning to the board then. On 4254, we've heard staff recommendations, and is any discussion we need to have, or do I hear a motion?
Mr. Chairman, I will move that we deny case 4254 based on staff's recommendations.
Okay. Have a motion to deny 4254 based on staff recommendations. Do I have a second?
Second.
Have a motion and second. Discussion on the motion. If not, all in favor vote aye. Aye. Any opposition, vote no. And the ayes have it. Okay. Our next case is case 4293. Kevin Flemons is requesting to use property for short-term rental. The property is located at 2976 Saundersville Ferry Road, parcel 23 on Wilson County Tax Map 11. It consists of 5 acres. It's zoned R1 residential. The property received an easement variance from the board on December 16, 2001. We'll hit staff recommendations on 4293.
Mr. Chair, the applicant is requesting to use the property for a short-term rental. Staff members have received a business plan stating how the applicant considers using the property. If the use is granted, staff recommends the business plan be made part of the approval and put the applicant on notice that if there are any changes to the structure or expansion to the use of the property, the applicant must appear before the board with a revised plot plan and business plan for approval. The caretaker for this property is located at 1510 Mount Vernon Court, Mount Juliet, Tennessee. If the board approves the request, the applicant must provide contact information to WEMA, the Wilson County Zoning Office, and the County Sheriff's Office. The home is a 3-bedroom, 3-bath with a limit of 6 guests. Typically, the board will allow 2 guests per bedroom. Airbnb short-term rentals are used permissible upon appeal in the R1 zoning district with a minimum acreage requirement of 2 acres. Given the language in the zoning ordinance, staff can recommend approval of the short-term rental. If the use is approved, the board typically approves the first-time request for a period of 1 year.
Okay, who's here to represent 4293?
I'm Kevin Flemons,
Okay, pull that microphone over there. We thank you, sir. And your address?
2976 Saundersville Ferry Road.
Okay, and what would you like to tell the board, sir?
Pretty much what the request was, the short-term rental approval.
Does the board have any questions for the applicant?
Okay, assuming this property has an easement, is that how you access the property?
Right from Saundersville Ferry.
Is there or could there be any issue as far as people accessing it that way?
No, sir.
Mr. Blades?
Yeah, I see you've got the quiet hours from 11 p.m. to 7 a.m. I think we normally establish that hour or a few hours earlier than that. What do we normally do, 8 or 9 at
I
night?
think it's typically 10 p.m. to 8 a.m.
10 p.m.?
The 8 a.m. is what I think most of your
So you'd be willing to change that to 10?
That's fine.
Okay,
Okay.
that's all I have.
Anyone else have any other questions for the applicant? Okay. If you would please step back just a moment. And does anyone else here wish to address 4293? Yes, excuse me.
Yes, go ahead. Thank you.
Name and address, please.
2974 Saundersville Ferry Road.
Name.
Natalie Korb.
Go ahead.
Yes, I am, the applicant and myself share a road, a driveway that every single Airbnb person would need to drive through in order to access this property. If you take a look, this is a Google Earth map. My property is all of this area here, and as you can see, the house is right there. You literally have to drive through the middle of my yard, right there. That's my house to get to this property.
It's a shared driveway?
It is a shared driveway. It was an exception made to this woman who built the house before we all got there. When we purchased the home, no one was living in that house. It had been in probate for 8 years, so therefore there was no traffic. And now we have our neighbors who we are very friendly with, by the way. We mow their lawn, we help them out. But the road itself, before you even get to this shared driveway, the entire road is a private drive. It's the reason why we purchased this residence. It's not at a dead end, but there's only 10 driveways on this entire road. This, in addition to that, this driveway is 100% shared with us. And you have to pass our home in order to get to this property. So imagine having anyone drive through the middle of your yard just to get to their home. As I said, it wasn't there when we first moved there, knowing the possibility would be there. But the last thing that we want is more traffic or an Airbnb of strangers driving through the middle of our yard to get there. Next, I have a special needs little boy. I'm concerned for safety of strangers staying in this house of our neighbors and driving through our yard. I don't know when, but to be able to access this residence. My little boy is 8 years old. He's very friendly. It's a beautiful area. I would assume if I rented this Airbnb, I would want to go for a walk. Well, guess whose yard you have to walk through to go for a walk? You have to walk right through our yard. That road or that driveway is where my little boy plays. That's where he rides his bike. That's where he goes. And so it's inevitable that strangers, and I don't know how often, would be in the middle of that yard, in the middle of the property. And I don't know these people. I don't want my little boy talking to strangers like this, especially at any level of frequency at all. This house is on the lake, so I would assume that it's going to be a party house, or people are going to rent it in order to want to have a lakeside grill or barbecue or people or different things like that. I'm concerned about the noise. I'm concerned about any bad influences around my child and around my family. And then the other piece is that this passes our swimming pool, this passes our hot tub, this passes our land. The privacy issue in of itself, there's really no way to get around it except for to put some sort of fencing or something around it. We as residents are responsible for maintaining this entire private road. Myself and Mr. Fleming are responsible for maintaining this driveway. That's not a city road or a city driveway. And so just any additional people coming in and out, the wear and tear of it by itself would be something that we would be responsible for paying for. I am concerned about my property value, knowing that this, again, is a residential area. There are only 10 residents, and all of this was part of an original 100 acres that our neighbors are still with us. We're all very close and been there for a minute. And we're very protective of this area being private and safe. Not all of our neighbors were able to attend today. One of our neighbors who has what we'll call the head driveway in the neighborhood is here today. And she is the first driveway that anyone passes coming on this entire private road, and she's always been notified first of any variances or anyone that wants to make changes within the road. So she's here today, but I have spoken to some of our other neighbors. One of the other plots has a home that was purchased for a college-age daughter. And they said that the reason that they purchased this home was because it was on a private road and that there wasn't the mainstream traffic coming out and there weren't strangers there, so they felt safe with their daughter being in this house by herself and attending school. And so the other piece is that we have aging parents right now. My mother-in-law has Alzheimer's, and she stays with us very often. With Alzheimer's, you want routine, you want familiarity. She has to go out walking. I don't want her walking with a walker on our driveway, which is the same road that these renters would have to drive through to be able to get to the Airbnb. I don't want to have to worry about all of those different things just so that our neighbor can rent out this property. So I wanted to be able to voice my opinion about that I absolutely oppose this and am not okay with this.
Thank you, ma'am.
Can I ask you a question?
Absolutely, go ahead.
Got a question for you. This is a legal right-of-way. You keep saying it's coming through your yard, but actually it's a legal driveway, correct? To get to his property. What's that?
What do you mean? I don't know the difference.
A legal right-of-way is a right-of-way for him to get to his home.
Correct, he has to
Okay.
go on this road.
It's not through your yard, it's through a legal driveway.
We own the property on the other side,
Okay, I understand.
so it is through our yard.
But he has a right to use it.
Absolutely,
Okay.
absolutely.
One other question.
Yes, sir.
What would be the difference if he decided to rent this house out completely on a month-to-month basis? Nothing to do with Airbnb, just a regular rental with a couple with 4 adult children. Difference, when you're talking about traffic, what's the difference?
You have to know your neighbors. It's familiarity of being able to know who your neighbors are in a private area where you can feel safe. It's about not having any say or control at this point over who it's rented to. Why are they renting instead of owning? I don't know, but the
I
reality.
think a lot of these comments,
I won't get
though.
to know.
I think a lot of your comments, though, would be the same if he lived there or someone else lived there, or if he did decide to rent it out for 6 months at a time, which would be his absolute right. He wouldn't have to be here. A lot of your concerns would be the same in those scenarios, would they not?
Many would be the same, yes. I mean, it comes down to safety and privacy. I know him. I know his wife. I know his 4 children. We share a son that has the same name. We know who they are. And I'm just voicing my opinion of, do I want additional strangers that I don't have any control over? I don't know who they are. I don't know anything about them coming and using this legal right-of-way that happens to go through the middle of my yard or my property. Why would I want that?
I think I remember it, but the right-of-way was established, the easement was established before you bought your home?
Correct. It was established as an exception that she could build the house, and she meaning the previous owner of that house, yeah.
So you were aware it was there when you purchased?
Correct,
Okay.
correct.
Let me ask the applicant, does your home that you have, this lot looks like it has frontage on the main driveway, the main road. Is that correct?
You can't get to the house from that frontage. It's a very steep valley. So it does go, Saunderville Ferry does go around the back side of the property, but the house is on the lake side of the property.
Mm-hmm.
So there's really no way to get to the property going from Saunderville Ferry Road.
I see, okay.
You'd
Thank you,
have to
ma'am.
build a separate road or something to get to it.
Gotcha. Thank you, ma'am.
I have a quick question for maybe council. Was Airbnb, provided they make the criteria or kind of allowed by state law or whatnot, do we have any criteria as far as it being on an easement or on a private drive? Is there anything? And maybe for Chris, or have we ever,
We don't have anything in our court ordinance that says they have to physically touch public right-of-way. I mean, we've got a lot that dictates Airbnbs being landlocked is not a determining factor currently.
so we have rules and guidelines for Airbnb and having 50 foot of road frontage to a public road would not be in our,
It's not part of our Airbnb to request a variance. I mean, that is part of creating a legal tract of record. This is a legal tract of record. It is landlocked. So, I mean, it's been approved with the
not
easement.
a legal easement granted access.
Yes, sir. And that easement's, I don't know the date on that. I wasn't prepared to answer that question, but I know it's been around a while.
Okay. Mr. Jennings, the lady in her testimony cited safety concerns. That's her concern. Is that, since she didn't mention that she was a law enforcement officer or anything, that would qualify her as an expert, is that something we can consider?
You can consider her testimony as a layperson, but not as an expert.
Gotcha. Okay. All right, Commissioner. Oh, this lady wanted to come in.
My name's Sherry Clodfelter, and I live at 970 Saundersville Ferry Road. And I'm the main first driveway that you get to there. I've lived there for 27 years, built that house because it was down a private drive, and we would have our privacy down through there. I get my granddaughter every summer for the whole summer. I don't want her down in a road when I don't know somebody else coming down that road. It's a posted speed limit. I don't want strangers that I don't know. We have a big Christmas party every year, and we do things together. We know everybody down through here. I do not know Mr. Lemmings. I've never met him before. But just want to keep it safe through there. I want to be able to, my grandchild, to ride her bicycle down to see her son and play. And I don't want to fear in this time of our, the world that we have, that somebody pick her up, I don't know. I don't want somebody that I don't know down that road,
Is it gated?
No, sir, it's not gated.
So anybody could drive down the road
Anybody can
anytime?
drive down there. It's posted, though, it's a private drive. You're not supposed to go down that private drive because there's 10 residents down through there. We all know one another. We all take care of one another and just don't want a stranger and, down there. I mean,
Thank you, ma'am. Commissioner.
Lauren Breeze, 1014 Bellwood Drive, County Commissioner for District 18. I just have one question that was asked of me by residents. I'd like to refer to the county attorney on this situation. So being that this is on a private drive, any additional cars and traffic that come through that might cause more maintenance to be needed for that private drive, obviously would be a civil matter between all of the residents on that road. However, if this body allows an Airbnb to be opened on the end of a private drive, which then leads to additional maintenance and expenses incurred by the homeowners, what is the liability of the county at that point?
But before how do you know
How do I know what?
there'll be additional traffic if it's a B&B?
Because people will be renting the Airbnb and have cars, right?
He may live there and he may have 8 kids and they may all have cars.
But then
So a full-time person might have the same traffic impact as an Airbnb is my question. How would you know that the Airbnb is going to automatically generate more traffic than a permanent resident or a long-term rental?
But at that point, though, then he would be liable for any maintenance that's necessary in the road. So we're not opening the door to a business at the end of a private drive that we don't own as a county. So that's what my question is from a liability standpoint, as to if we allow this and set this precedent.
I don't think we have any, I'll address that.
Do you understand?
I don't think we have any liability because it's for the quasi-judicial body that has immunity from the decisions they make. Now, having said that, we don't have any precedent where this has happened before. And I do hear concerns about how the private road's gonna be treated, who's gonna pay for it. The issue of safety can happen on any road, as we know, as the chairman's already alluded to. But precedent, you know, think about this as precedent, because this may not be the last one.
I didn't think we were a precedent-setting body.
I know this much, if I was over there and you set one in the case and I came in with another case and it was the same thing, I'd remind you.
So maybe it's as much a fairness issue as a precedent.
Okay.
And
You're free to, I mean, we all know on this side of the war, perhaps the folks out there don't, that every individual case is decided on its own set of facts, unless there are two identical cases and there never is. So, each case, y'all decide and do a good job on hearing the facts, but, this is different, that's all I'll say.
yeah, got you.
Thank you.
Anyone else wish to address 4293, short-term rental for Flemings? And if not, I'll close public hearing in regard to this case and turn to the board for a motion or further discussion.
I've got, this may be an open-ended question, but just because a property is suitable or meets all the requirements for Airbnb, does that always mean it's the right place for one? Is it suitable for that neighborhood? That's just, like I said, probably an open-ended question, but is that ever taken into consideration
I
when?
would say no. It's just because they meet all the requirements does not automatically mean it's suitable.
Okay.
So,
Yes, sir.
yeah, based on the information we have, it says the applicant's going to try to maintain at least 25% occupancy per year. I mean, year-round. If he does that, we're talking about maybe a week, a month. And let's look at it this way. Most of the time, these Airbnbs, they don't come and rent it for a week. It's a weekend. Probably through the summer, winter months, he's probably not going to have anybody there at all. So as far as the amount of traffic, you would have a lot more traffic if somebody was there, like I said earlier, with a family. And also, there's a lot of restrictions. I know the county commission spent a lot of time on these Airbnbs, because we get updates all the time where they've changed. And there's some requirements. The requirements are, as he knows, you got to have somebody as emergency contact. You've got to be listed with the county. I think this would be the sheriff's department. So if somebody has a complaint, there's places to contact with the complaint, as well as some of the folks know him anyway. So as far as the safety part, just because somebody moves into a neighborhood, whether it's a short-term or long-term, doesn't mean it's a safety issue. That's the way I look at it.
You know, it strikes me that this is a business. You know, what we're doing is really opening up the permission or granting permission for a business. We're going from a residential use to a business with a residential component. And so I asked myself, you know, we don't normally allow businesses on offshoot private multi-family driveways. And I understand, Howard, what you're saying, that, you know, that's what his business plan says. He'd like to rent it, you know, 25% of the time. But I wonder if he could rent it 100% of the time, wouldn't he? You know, I don't think he's saying I'm not only going to rent it 25. It's just I hope to rent at least
Right.
25%. So I wonder down these, little driveways, is this the proper place for something like this?
I've not been in the area, but it's just from what I've heard testimony, it just doesn't appear to be a suitable place for an Airbnb. That's just the way I look at it.
I don't, they make some good comments here about, not wanting it in their neighborhood and not wanting strangers in their neighborhood. Every Airbnb in the county has that statement, Every time an Airbnb comes in somebody's neighborhood, those residents don't want it in their neighborhood because they're strangers. So to me, that is not a component, but what is a component is they've got an easement across somebody's front yard and on the end of a private drive. So that, to me, that is a game changer to this request over the ones that we hear every other month.
If he were on he fronted on a public road.
Exactly. Then the fact you say, well, we don't want nobody wants strangers in their neighborhood on Airbnb. So to me, that's not an issue here. What is an issue is he's on an easement and he's having to cross, on a private drive. So that, to me, that is a game changer.
So that adds a component of invading on other people's
Absolutely.
peaceful
Absolutely.
existence.
And even though it's a public easement, and I'm sure it's on the deed, it gives this gentleman a right to live in that house or do certain, but does it necessarily give him the right to turn it into a business and rent it into Airbnb? I probably have a problem with that, personally.
I lived on a lot of acreage. A long time ago, built the house. I do also have a shared driveway. The people that sold, the new people that have come in, have a lot of folks, even though they don't bother us, they share this driveway. They come in and out of that drive constantly. I have no idea who they are. I have no idea who comes down that driveway. I'm out there. They've never spoke. They've never done anything. Bothers me a little. I'm way out in the country. So, like it's been said, I understand the Airbnb. What bothers me, just like was stated up here, is this an appropriate place to put an Airbnb?
Okay.
It's a safety issue.
Any other comment? And 4293, we've closed the public hearing, and we've had several comments from the board. Do I hear a motion?
Mr. Chairman, I will move that we deny case 4293 based on testimony given and the fact that it is on an easement. The access is on a private drive with an easement. Is that clear enough?
It is for me.
I'll second.
Have a motion and a second. Discussion? If there's no discussion, all in favor of the motion as stated, vote aye. Aye. Opposition, vote no.
No.
Mr. Blaze votes no, so the motion will pass with 4 voting aye, 1 voting no. Thank y'all for coming. Beg your pardon?
Wait for me to comment.
No, sir, the appeal from this board is still the Chancellor's Court. But the hearing is over, the vote has been taken, this decision has been made.
Thank you.
Thank you. Okay, our next case is case 4294. Brian Keith is requesting a variance of 512 feet from the lot size requirement of 80,000 square feet. The property is located at 2929 Cathis Road, Lot 2, Collinsworth property, parcel 21 of Wilson County Tax Map 94. Consists of 1.46 acres, currently zoned A1. If the variance is approved, a portion of Lot 1 will be added to Lot 2, and the proposed lot size will be 79,488 square feet. We'll get staff recommendations now on 4294.
Mr. Chair, the applicant on behalf of Michael Collinsworth is requesting a variance of 512 square feet. Excuse me. From the lot size requirement of 80,000 square feet, staff can recommend approval of the lot size variance as it brings an existing 58,400 square foot non-conforming lot closer to the minimum lot size requirement of 80,000 square feet. I know this, these lots are both existing, so the existing lot is substandard. This is bringing that lot closer to the requirement. It's still going to be roughly 512 shy.
Okay. Who's here to represent 4294?
Brian Keith, Keith and Associates Surveying,
Address, please.
1012 Sparta Pike.
Go ahead.
We started this process because of some encroachments on these two lots. They were existing lots of record by plat. It was a father and son owning these lots, so you would understand how that you can get encroachments that way. But in attempt to sell the smaller of the two lots, those encroachments needed to be remedied, have a remedy for those. So we moved the property line as much as we could, and we came up that much short. So that's why we're here today, Mr. Chairman, to ask for a variance for those few feet to try to get these lots, property lines in better shape and as close as we can get to the 80,000 square foot minimum lot rule.
Okay. Questions from the board for the applicant? If not, does anyone else here wish to address 4294? Yes, sir. Come forward, please.
Morning. I'm Mike Collinsworth, 2893 Callis Road. Just want to say that this is a piece of property that between me and my dad, we've owned for 50-plus years. And he passed away in October, unexpectedly. And my mother passed away a month later. And we tried to, my daughters and my brother's daughters, see if they wanted to live there and offer it to them, to keep it in the family. But you know how kids are. They go and get their own homes, and they want to live where they live. And so through a lot of discussion, my brother and I have decided that as hard as it is, we need to sell it. But I can't give them any more property than I have. I've redone my water line and some things in the back. If we give them any more property, it's going to encroach on where my water line is now on my property and my garage in the back. So this is as much as we can give them, and we've come very close. But if we give them any more, if I ever have issues with my water line or anything, I don't want to be digging on my neighbor's property, or give them any reason to not let me fix my water line or something. But we've given them as much property as we can in order to make this a piece of property that we can sell.
Thank you, sir.
Yes, sir.
Anyone else wish to address 4294? Collinsworth case. Okay. If not, I'll close public hearing and turn to the board. Do you have any comments, or would you like to make a motion?
I make a motion that we recommend, approve this upon staff recommendation.
I have a motion to approve case 4294 based on staff recommendation. Do I have a second?
Second.
I have a second by Mr. Crockett. Any discussion on the motion? If not, all in favor vote aye. Aye. Opposition vote no. And the ayes have it. Thank you all for coming.
Want this back? We've got copies of it. We had copies of it. I don't know if you need them for some other reason.
Need them, but I'll
Okay.
dispose of them.
Okay.
Our next case is case 4295, Pat and Ron Gibson requesting a variance of 5 feet 4 inches from the height requirement of 35 feet. If the variance is approved, the proposed house will be 40 feet 4 inches tall. The property is located at 1540 Holland Springs Road, Lot 1, Robert Van Huger property, parcel 37.01 on Wilson County Tax Map 46. Consists of 5.03 acres, zoned R1 residential. We get staff recommendations now on 4295.
Mr. Chair, the applicant is requesting a variance of 5 feet 4 inches from the height requirement of 35 feet for a residence. Given the language in the zoning ordinance, staff cannot recommend approval of the height variance. An additional point of information, there was a home on Horn Springs Road that I believe the board gave a variance to in the past. I'd have to look up the exact date. The stipulation that you put on the applicant at that time was they were required to sprinkler the home if they wanted to go that height, and that was the entire home, not just what was above the 35 feet. They, at that time, amended their house plan to not have to deal with sprinklers.
I know there's been a couple of times that we've heard these type cases. Most of the time, we told them if you want to go above the 35 feet, you have to sprinkle. There was one case where they were on a lot that was a slope, and the 35 feet came into play on one side, not the other. And I think in that case, we told them they had to, sprinkle whatever was above the 35 feet. But, yeah, the
that's-
sprinkler system has always come into play.
Yes, sir.
Okay, all right. So, in regard to 4295 Gibson, who's here to represent that case? Yes, ma'am.
Well, I feel sort of defeated before I start, but I'll go on.
Well, don't feel that way.
2 years ago, we bought our land and hoped to build our home to retire in. We searched for a year for the perfect plan. We found 2 homes already built in Wilson County using the plan, one on Burford Road and one on Cooks Road. They kind of became our inspirational plan. We met with a home designer who's designed a lot of homes. She helped us tweak the plan for the inside of what we wanted, and we thought everything was going well till we went to the zoning office, and they told us about the 35-foot limit, which surprised us because there's a lot of homes built on Horn Springs Road that are tall, we didn't realize there was an issue. I would like to point out it's just the center of the house. It's not the entire roof. The house is 101 feet long, and it's just this little center portion here that's about 42 feet. That I don't know if you can see. The house plan, the roof pitch makes the house. It's called a modern Gothic farmhouse plan. We did ask the home designer if it could be modified, and she said, well, not really. It would be a totally different look, a totally different plan on the inside and outside. There's no living space in that upper area. It would just be HVAC lines, where I don't feel like would have a negative impact on the properties around us because it is on 5 acres. There's 47 empty acres behind us. The people to the left of us have a really large house, and it's quite a distance away. The people to the right of us, it's just a vacant 8 acres. And you really can't see the house from the road because it's behind another property. We felt that the house fit the style of the homes that are being built on the Thorn property that auctioned. A lot of those are taller, more modern farmhouse homes. But like I say, it's the roof pitch in the center of the house that makes the unique style of that design. And, we've already invested some time and money in it. We've got our water line, our septic permit, stormwater permit, tree removal, driveways added. And we were just asking for that variance.
Thank you, ma'am. Anyone else here wish to address 4295 Gibson? Mr. Cowden, did you have anything to add to this case? It sort of gets into your area.
It also gets into residential where you need the chief building official in this room right now. There is sections in the code where required in the residential code. I just don't have that answer right.
That's fine. I just, okay. Anyone else here wish to address 4295? Last call. Okay. I'll close the public hearing and turn to the board.
Just as discussion, you've already mentioned, we don't set precedent, or we do set precedent, or whatever.
Well, I think we set more fairness than we do precedent.
Okay, well, whatever word you use for that. So obviously, this doesn't seem to have much impact on the neighborhood based on the location, and it's off the road and all that. But then there's the what if next month somebody wants this house on a half-acre lot or 1 acre lot, and they're sitting right out in the middle of how do we differentiate, I guess?
Well, there's nothing around there now, but according to their plan, there's 68 feet on each side from the property line. And I just, as Christopher mentioned, I was going back to some of the others we have heard over the years, and we've done a couple of different things. Like I said, one of those lots, I think, was on maybe Rocky Valley Road, and it was on a slope, and there was a height issue on one side.
Right.
And those folks, I think we asked them to sprinkle what was above 35 feet, because the other side was well below. Yes, ma'am?
I do have a question. Would it
Can I
make,
finish?
yes,
Okay.
please.
And then, I'm sorry, and then the other ones, I think, that were just flat over 35 feet, we asked them to sprinkle the whole house. Now, that's a PVC line and some residential type sprinkler heads, but that's what it is. Yes, ma'am.
I just have a question. She did state that there wasn't any living area that was above the 35 feet, that it was just going to be HVAC and things like that. So I was just wondering if that would make a difference.
I would think in most houses with that steep a pitch, people aren't gonna be living up in the top 5 foot of the house anyway, up next to the ridge.
I think if anything caught fire, you might be as likely or more likely to have a fire in the heat and air system than a bedroom, but I don't know. Any other comments? Okay. Do I hear a motion?
You bring up the fact that we have allowed some of these with, because I can't really remember a whole lot of these coming up. Pretty rare, but
It's pretty rare.
I'm not saying we don't, obviously, I'm just saying I don't remember.
But I remember 3 specifically, and I remember the one that had the slope, because we only asked them to sprinkle what was above the,
Did we allow, to best you recollect, do we allow all 3 of them, or do we deny
with
them?
the, no, I don't remember ever denying
Okay,
one, but
okay.
we allowed them with the stipulation about the sprinkler.
Sprinkler.
They all 3 had a sprinkler stipulation of some kind.
Right, I'm with you.
I've got one more question. There was one on Murfreesboro Road.
Yeah, I remember that one.
But he wasn't over the height, he was just, it was just big.
Something, I can't remember.
No, he had a height variance.
The height.
Did he have a height variance?
There was no livable portion. It was a very unique height variance because it was actually a 1-story house on Murfreesboro Road. Like all the livable was on the first floor. There was no second floor of that home. It just had a very unique roof pitch to get it over that 35 feet. In that instance. Granted, yes, that house I think was north of 10,000 square feet, so there was the size that got brought up as well, but all of the livable portion of that house was on the first floor. I can't remember the outcome of your motion on that particular case, though.
It was approved, I think. Well, I mean, is that what
Well,
you?
yeah, it was approved. I don't know the stipulation.
Oh,
on
okay, right.
the sprinkler.
Okay. Again, do I hear a motion in regard to 4295?
I'll make a motion to approve variance.
Have a motion to approve the variance on 4295. Do I have a second?
Second.
Have a motion and a second. Any discussion?
Are we gonna address the sprinkler issue, or are we just leaving that off? I'm just, it's part of the discussion, I'm just throwing it out there.
I know, and you considering, and I don't want to open up a can of worms, so y'all feel free to correct me. But I think under the circumstances, HVAC up there is not a livable space. Does that qualify for an exception?
I would say that none of those we have approved technically qualified for an exception. We approved them with the sprinkler to add some level of protection for structure and for life safety. But I would say, technically, there is a height restriction of 35 feet, and there's nothing to any of those that we've heard that would technically give you a reason to grant a variance. Again, we did the sprinkler trying to add some degree of protection for structure and life safety.
Is it appropriate to have the owner come back up?
Public hearing has been closed, but if you want me to reopen it, I'll be happy to.
Okay. Would you like to come back up?
Ma'am, would you come up, please? We'll have more comments.
Is the, and I don't know anything about the sprinkler system, would that be a burden for that area to have?
It would.
It would.
We called and people said, we've never heard of that. We called asking, would that be something we would need to do? And some of the plumbers we called, they were like, we'd never do that. So I don't know. I mean, maybe we didn't call the right person, but
You call a fire sprinkler contractor?
no, I don't know who. He did. Okay. But our question was,
Well, commercial buildings all the time.
but,
Sir, if you're going to give testimony, you'll have to come up and give your name.
okay, sorry. I mean,
Now, one day,
If you would give us your name and address, please.
Ron Gibson, 715 Scarlet Place.
Yes, sir. Now what you got to say?
And I called a number of people one day, I just going down the Googling numbers, and I could not find one.
Googling.
People that would put in a system
in your home,
in my home.
in your home.
They probably exist, but I called tons, and I could not find any. You know, I'm just saying I didn't have any luck. I do not feel that we need a sprinkler system in this house. This house has been built twice in this county.
In this county.
Last year, it was built on Burford Road. And then the year before that, it was built on Cook. Same house.
Same height.
Same, yeah,
You can see by the height.
I can take you to 100 houses that 40 foot
And
tall.
it's that plan.
Let me
I
be
understand.
clear here, sir.
But I'm just.
If you would, please,
Yeah.
Yes.
we're not considering 100 houses, and we're not considering Burford Road, and we're not considering,
understand
it's this case.
Right.
Yes.
It's your house, your application.
Yes, sir.
We understand.
No. Anything else, the board, any other questions you have?
Can I ask a question?
Absolutely.
Christopher, when we did Road, and they did that height, did we require them to put a sprinkler in?
I don't believe so at that time.
Never know.
I do too, and we did, I didn't think we did. I just wanted to verify.
I don't think so, and I think the reasoning behind that motion was that all of the livable space was on the first floor, as it had no second story.
Exactly.
It was just a very unique designed house.
I think
I would have to,
other discussion about the fire hydrant being next door and
there may very well been. I think there was one with about 100 feet from that home.
There was discussion in that one about there not being adequate water flow for a house of that size.
discussion was water flow about
If it caught on
pumper
fire.
truck.
Well, something about it, if there was enough adequate water, something about water on a house of that size. But anyway, based on, the square footage of it.
Okay. Any other questions from the board? Okay. Now let's close the public hearing again. Let's see if we can get a motion. Okay.
We've got a motion in a second.
We got a motion from who? Mr. Crockett to approve.
Robinson, second.
And Robinson second. Okay. Any discussion?
And I know we wore this out. Do we want to put any kind of amendment about a motion about based on the lot size, it's off the road? I fear next month there's going to be somebody on a half-acre lot, and the neighbors aren't going to like it.
Sure it's clear what our intentions were. Yes,
If you could have, that motion, I'm just throwing this out there. Could it be based on the lot size? It is it's 5 acres. The house is way off the road or something. I don't know. Just anything that would make this case, as Mike would say, unique to the case that we might hear next month. I'm just throwing that out there. Or does that even need to be in the motion? Mr. Chairman?
Well,
Something that makes this case unique.
as Mr. Jennings has told us, you make your bed, you sleep in it. So evidently we've got a number of different decisions out there. We've heard them all separately. Some homes we've allowed sprinkler, some homes we required sprinkler on the upper level. some of the cases, we've had them sprinkle the entire house. I do not agree with the applicant's statement they can't find anybody, because I think there are quite a few of these homes that are sprinkled with a residential sprinkler system. A lot of people do that voluntarily just for peace of mind. And then evidently we approved the 231, I think that was, I can't remember, Patel.
It was.
Yeah, that was,
And he had fire protection, right close by. So there's a wide range. I don't know that we've ever approved one, just approved it.
Right, okay. Fair enough.
Just without any.
Let me go ahead and amend and put the lot size, do the lot size, the distance from any other structures.
Okay, so restate your amendment, please, Mr. Crockett. To approve with.
Approved based on the lot size, the location of the house, in consideration with the surroundings.
Okay. Do I have a second to that motion?
Second.
I have a motion and a second. Discussion on the motion. And then all in favor vote aye.
Aye.
And opposed vote no. And I vote no. Howard, how'd you vote?
I'm going to vote yes.
Okay, so there's the motion to approve the variance is approved with 4 voting aye and 1 voting no. Thank you. All right. Our next case is case 4296. Ned Hanson requesting a variance of 5 feet from the easement with requirement of 30 feet. Applicant is requesting to utilize the easement to build on the back portion of lot 10 and 11. The easement came of record May 16th, 2025. The property is located on Noakes Road, portion of lot 10 and 11. Kaiser property, portion of parcel 32.06 on Wilson County Tax Map 80, consists of 28.41 acres, zone A1 agricultural. We get staff recommendations on 4296.
Mr. Chair, the applicant is requesting a variance of 5 feet from the easement with requirement of 30 feet. The lot in question was created May of 1998 via a boundary survey. At the time of creation, the lot had 50 foot of road frontage, and if you want to see that reference to the plat, it's the 3rd page in your packet of the recorded plat from 1998. A portion of the lot was then sold in 2009 via deed given a 25-foot easement through the property. This created a non-conforming landlocked tract at the time. Because these are not older tracts of record and were originally created in 1998 as legal tracts of record, staff cannot recommend approval.
Who's here to represent?
I do have one follow-up comment, sorry. Stormwater Department has been in touch with the planning office. They are advising that the applicant reach out to them to pull the proper permits because land disturbance has started on one of the properties.
Okay. Who's here to represent 4296 Hanson?
Morning.
Morning.
Ned Hanson. I did want to make one
Address, please.
I'm sorry?
Address?
2004 Bennett Drive, Lebanon.
Okay, go right ahead.
I wanted to make one clarification that you, for the May 16th, 2025 easement, that was actually a scrivener's affidavit clarification of an easement that was created in 2009. In talking with the planning and zoning folks, when they reviewed the easement, which was originally drawn up to access the land right there, lots 10 and 11, or the back portions of lot 10 and 11, it didn't specifically describe the land. So the scrivener's affidavit describes by a meets and bounds description that land. So the actual easement has been in existence as a 25-foot wide ingress-egress easement to that property since 2009. Christopher had mentioned that we've done some work out there, which is true. I've cleared some trees. done some grading. I have some equipment. I'm a civil engineer. When they had come out last week, we were doing a little bit of piling up of some topsoil. I have put a silt fence around that. Maybe that's neither here nor there. I will get a building permit if my variance is approved. So, and then I can answer any questions.
The board have questions for the applicant? Okay. Does anyone else here wish to address 4296 Hanson? Yes, sir. Come forward, please. Excuse me, let him step up here if you would.
I didn't sign in. I didn't know if I just want to clarify. So I'm Danny Hale. I live at 474 Noakes Road. Sorry.
Did you take the oath?
Yes, I did.
Okay, go ahead.
Where exactly is this running?
Can someone at the computer just point to the folks here with the paper copies? It's the yellow highlighted line. If I could grab a mouse, I could point to where it is. So there was some confusion with Danny and Mike Abram since they had to be notified because they're adjacent landowners. They were concerned that the easement was going through their properties. I think that's what they.
Well, the easement's not.
That's if I figure that out and it's not going.
It's not moving.
Correct. It's an easement that's
The one you have now.
right since 2009.
I'm out.
All right.
Okay.
Can I go with him?
No. No. Okay. Anyone else here wish to address 4296 Hanson? If not, we'll close public hearing on 4296 and turn to the board for discussion or motion.
Question for staff. Is that the easement he has was created,
2009.
is it is it a legal easement?
Yeah, it's a legal easement that was created via property transfer with a deed. I mean, they have all the deeds in reference to that easement were done correctly.
Okay, why is he here?
Because now he has a landlocked tract that he's wanting to get a permit on.
How did that happen if he was okay in 09?
No, 09 is what created the issue. He just never pulled a permit. He created a legal access to access a landlocked tract, which you can access a tract. There's no issue with creating a landlocked tract for access. It's when you go to pull the permit is where we have the issue. When it was created in 1998, it had 50 foot of road frontage. In 2009, there was some property swapped from neighbors and sold, and they sold that. In essence, this was two tracts, so they sold a 100-foot by however long tract of land to the front property owners, now landlocking those two tracts. And they created an easement so he could access them. But that, just because he has a created access easement doesn't validate him for a building permit without a relief from this board.
Originally in 98, it was a track, it was like a flag lot. It had a
Yes, sir.
50-foot running in, and then it was traded away,
It was.
and now somebody wants to use it.
Yes, sir. And that ability to get that trade away is all these tracts involved were north of 5 acres, so you can do all that via title transfers. None of that comes through the planning office for approval.
Got you. Okay.
So I'm confused about allowing an easement. You're allowed to have an easement created to access a piece of property and bush hog it, farm it, do whatever, but you're not allowed to get a building permit and build on it.
Unless the easement complies.
Is what?
Unless the easement.
Well, unless it predates, unless it's grandfathered in.
But yeah, I mean,
I know if it's grandfathered in, but.
Let's say this tract was created in 68.
Well, I understand
and
that.
they had an easement, yes, they could get a building permit off of that easement. But this easement was just because he sold off his access, so the easement needed to be created so he could still access his property, and that was done via deed. But that doesn't, he's now created a landlocked tract after 74, but that doesn't give him the right to build on it.
So,
at present.
again, 90, late 90s.
98, yes.
And it was legal by all aspects. It had 50-foot of frontage, and it was good.
And then they sold it
And
off
then-
and made it, yeah.
Then they traded that away.
We traded away.
The neighbors, the owners amongst themselves.
They
just-
lost their 50-foot
They,
road frontage.
they swapped land and whatnot, and the 50-foot got traded away.
Did the county record that it'd been,
The county recorded the deeds. There is not, if you pull the plats on this property, it's the original one from 98. They never did a new boundary survey to show the new property
By
lines.
deed, they did away with it. Didn't go through the planning commission because of the lot size. And now, someone wants to use that rear track, and the only thing they have is a 45-foot easement, which,
25-foot easement.
oh what?
25-foot easement.
25-foot, which doesn't meet the required
Easement width.
easement width.
Well, okay, well then, so if he had a 30-foot easement, he'd still be up here, would he not?
Absolutely, yes,
It's
because
not the width of an easement, it's a fact.
Yep.
It's a fact that it's an easement created after we had zoning ordinances.
that's why he's up here. The easement width is to get a legal permit on a landlocked tract. That needs to be 30 feet.
Right.
But say the easement was 30 feet, you would still have to approve it's a legally created, or make it a conforming landlocked tract. He would still have to come before this board to request a building permit on a landlocked tract.
Because I guess getting back to somebody next month sells all their road frontage off, and then they create a 30-foot easement. They can't legally do that and get a building permit.
No,
Come
if that was the case, it would come up before you. They'd be coming before you to ask to get a building permit on a landlocked tract that was created after zoning was established.
And that's basically what this is.
Yes, but he's also asking for the 5-foot easement.
Right, I understand.
Yes.
There's two requests here. One is for 5 foot, and the other is utilize the easement to build.
Okay.
So there's actually two requests to make him whole.
Well, we grant 5-foot variances on easements all the time. But the other part, I don't know that we do all the time or not. I don't know that we have a history on
Yeah.
recognizing easements that aren't grandfathered.
Sir, we closed public hearing. Do you have something that's really relevant?
It's relevant.
Okay, come ahead.
So I didn't own the original property that had the 50-foot wide strips for 10 and 11 going to Noakes Road. Mike Abram owned all of the property of lots 10 and 11. I purchased from Mike Abram the back portions. So I just wanted you to understand that I didn't have 2 lots with road access and then foolishly sold off my access. So
When did you buy it?
I bought it in 2003 from Mike Abram. So
This mischief here was done in '09.
So at the time of 2003, I owned the lots 10 and 11, the back portions highlighted in blue there, and then also lots 6, 7, and 8 that adjoin to the south and have the road frontage. In 2009, I sold off lots 6, 7, and 8, and that's when the easement was created to my remaining property, lots 10 and 11.
Okay.
Okay.
Okay. Back to the board, 4296. Any other questions?
I guess, I don't know. I guess my question is, when you sold lot 7, why didn't you maintain 50 foot leading to this right here? Then we wouldn't be having all this.
That's true. So the landowner of 6, 7, and 8 passed away, and our intentions were to create his, a trust between his 30 acres and my 30 acres. And he died 11 days before the signing of that trust. So it's in a legal battle now that I've appealed to the federal court. But that's kind of an explanation for why, we've been business partners for 38 years. So in retrospect, it would have been wise to do that.
But I missed the part where you didn't go ahead and just make it 30 feet and, make it appropriate.
So that, I was not aware of the 30-foot easement requirement until I came to talk to Karen and Christopher about a building permit.
But you're a licensed engineer.
Well, I'm a structural engineer, so I'm more dealing with, steel, concrete, wood, masonry. I'm not a surveyor or a grading plan creator. Yes, I'm a registered civil engineer. I can do those things, but I don't keep track of all the codes and variances.
Okay. Any other questions or comments? In regard to 4296, then, do we hear a motion?
I'm gonna make a motion that we deny this upon staff recommendation.
Have a motion to deny 4296 based on staff recommendations. Do I have a second?
Second.
Have a motion and a second. Discussion on the motion. If there's no discussion, all in favor vote aye. Aye. Opposition vote no. And the ayes have it. Thank you for coming. Our next case is case 4297. Davis Fairfax is requesting a variance of 9 feet from the east side yard setback requirement of 10 feet and a variance of 7 feet between structures from the setback requirement of 8 feet. The existing carport is 1 foot from the east side property line and 1 foot from the proposed addition. Applicant is also requesting a variance of 9 feet from the east side yard requirement of 10 feet and a variance of 6 feet from the setback requirement of 8 feet between structures. The existing accessory structure toward the back of the properties are 1 foot from the east side property line and 2 feet apart. The property is located at 354 Twin Cove, Lot 9. Twin Cove is Group A, Parcel 29 on Wilson County Tax Map 14E. Consists of .39 acres, Zone A1 agricultural. The property received a variance of 8 feet from both the east side and west side property lines, allowing the home to be 12 feet from both east and west side property lines on July 12, 1979. We get staff recommendations now on 4297.
All right, Mr. Chair, I've split this up into 2 parts to try and clarify as much as possible. The applicant is requesting a variance of 9 feet from the east side yard setback requirement of 10 feet and a variance of 7 feet between structures in order to make an addition onto the existing home. That is for the carport in the front of the property. The applicant is also requesting a variance of 6 feet from the setback requirement of 8 feet between existing accessory structures. The existing accessory structures were on the property when it was purchased by the applicant. Those 2 accessory structures are behind the existing residence that is being added onto. This could be considered a hardship, therefore staff can recommend approval of the 9-foot east yard setback and a variance of 6 feet from the 8 feet between structures. However, this is not an older tract of record with the lot being amended in February of 2007. Therefore, staff cannot recommend approval of the 7 feet from the 8-foot separation requirement between the carport and the proposed addition onto the home. The plat was amended in 2007 to adjust a front setback line on the previously recorded plat that was recorded in March of 1963. Other than the front setback, the lot is the same that was previously recorded in 1963, and I give you that information because the board may choose to use that as a point. The only thing that was changed from the original lot in 63 was the front setback. It was originally called out as a 40-foot setback. It was amended in 2007 to meet our county minimum standards of 30 feet, and that is the only thing that changed on that amended, but doing that, it burns the grandfather clause of the lot. Clear as mud.
Okay. Who's here to represent 4297 Davis Fairfax? Yes, sir.
Good morning. I brought a lot of papers just in case you ask questions I don't have answers to.
You state your name and address, please.
My name is Davis Fairfax, and the address, the official address is 354 Twin Cove Drive, but it burned down. So my wife and I are temporarily living in her home that she owned. My first wife passed away with Parkinson's disease a few years ago. So my second wife, I found her in church and we got married. And I know that doesn't pertain here, but I just thought I'd let you know that things have changed. And so the house that we had was burned down, but there's still a foundation. And F.E. Warren is trying to rebuild that home. And so to rebuild that home, the foundation is a VA approved foundation, but they're adding to the front side of it. The kitchen and everything burned down completely. So they're changing the footprint versus what is shown on the records. There was a letter that I sent out to Mike Wilkerson for him to give his opinion as to whether or not y'all should consider it favorable. So do y'all want a copy of his response?
Mr.
I'm sorry. Mr. Mike Wilkerson is my neighbor next door at 340 Twin Cove Drive, Lebanon, Tennessee, 37087. And he's
submitted. You're welcome to. We can only consider sworn testimony that's given here.
okay. Thank you. So that being said and done, and I asked him if he could be here, but he's in construction and he couldn't be here. That's why he wrote the letter. What we're set with is the house that we had built or manufactured home, 3 pieces, was placed on this property in 2007. Prior to 2007, there was on lot 9, there was a single wide 14 by 55 that stretched east to west. And it had an add-on. That's why there's a picture of it on these drawings that we obtained. Behind it was a dark shaded area, which used to be a shed, and it was attached to a garage. But there's field lines behind that house. And so instead of driving across field lines, I chose to put in carports and driveways up around the front of the house. So the shed and the garage, I converted the garage, I put a floor in it and made it another storage shed, so there wouldn't be vehicle traffic across the field lines. I wrongfully assumed that it was okay for those sheds to be there because the house has been there since 2000. And so I wrongfully assumed that I didn't know, and that's my fault, that I needed to come here and get something approved that had already been sitting there for quite a long time. So this is why we're trying to close the door to the barn after the cow got out. I'm basically long and short, I'm applying for a variance to leave those buildings where they're at. Otherwise, I'll have to demolish those buildings because they're set into the ground in order to move them. And because our property, and I don't know any relationship you have to Paul Crockett, so I don't mean this, but Paul Crockett surveyed these properties 9, and he said, Mr. Fairfax, the property lines were drawn wrong previously. He said something about dead reckoning. He said, you're going to have to move this property line to lot 9 over to where it is right now in the county records. And so because the original property line run right through that double wide home sitting next to it. And so I agreed to it before I bought the property. I agreed to it, so, because I had 4 good pins from Mr. Paul Crockett. I knew it'd be good. So that's why it's such a thin, and I got a house going long-wise, because my wife with Parkinson's, we had to have single-level living. And now my second wife, 86, we still need single-level living. So I would have to destroy those sheds, both sheds. And they're my main area of storage, because my wife doesn't like a cluttered house. But I put all my tools and laundry and all, not laundry, work tools and stuff in those sheds. So I'll have to destroy them if I want to get away from the lot line. And I'm asking that I don't have to destroy them if y'all can grant me the variance. We're not going to add any more buildings on that property right there, other than what Mr. R. Warren Construction, and I brought their proposed plan. They had already not demolished, but got rid of all the burned up stuff and they were getting ready to start a reconstruction of that house. Why they didn't submit for a work permit back in October, because the house burned down in September. So we've been living temporarily since then. Why they didn't do it that's neither here nor there. But they did apply, come in finally. After I got another contractor in the same company, he came in and started to apply for a work permit, or what do you call them, to build a house, or reconstruct a house.
Building permit.
There you go. Thank you, sir. And he came in to apply for it, and Wilson County did their job, said, no, we got some issues here. And so this is why we're addressing this 17 years after I had moved in. Otherwise, I wouldn't be taking your time up today. So I
put these buildings in without a permit.
These buildings that are there right now were there when I bought the property. Okay. I inherited those.
Somebody else put them in without a permit.
Yes, sir. The previous owner, you drove down this side driveway around the back and into his garage, which I converted to a storage building, so there wouldn't be any traffic over the field lines.
The board have any questions for this applicant?
I got one. Let me see that picture. This picture we provided has several buildings on the property, it looks like. There's a couple of them pretty much already knocked down, it looks like. I did pretty well. See the picture up here?
I don't have a copy of that. Maybe I should, but I don't.
Well, there's,
okay.
You've got some buildings there that pretty much already just about knocked down.
All right, these two buildings, this is trash that came from inside this house.
All right, I'm talking about that building, these two buildings right there.
Both these buildings are still sturdy. They're my storage buildings. They're still standing and they're still sturdy.
So you've already, based on this picture, you've already in process of building a house.
And I trusted R. Warren to be, I said, make sure you have all the permits. He said, we got it. And so I fired the half owner.
Yeah.
And I said, Liberty Mutual Insurance, I want another contractor. And so they got a contractor now, AC, I can't remember his last name. He's now working with Wilson County to get a building permit to modify this burned down.
That's why you're here, to get the variances.
Well, the variances are so we can get, this should have already been approved, because these buildings have been there since 2007. So the variances, and in addition, and I agree with you, sir, in addition, they're rebuilding the front of this house. They're adding on the front of the house.
Which would be this here. You see,
Yeah,
you see where
they've already scraped it all off.
yeah, because,
This part is still burned.
yeah, you can see where it's
They haven't
burned.
They haven't finished demolishing yet because they finally found out they were supposed to do it right. So that's
Okay.
what we're trying to do here. They're going, if the variances are granted and I get to keep my storage shed, then that's fine, because that's where all our stuff is right now. Then they can apply for a building permit to continue this process, from what I understand.
Any other questions for the applicant? Okay, do we have anyone else here wish to address 4297 Fairfax? Okay. If not, then I'll close the public hearing. And does the board have any other questions for the staff or any discussion?
I think staff stated this lot may have lost its grandfather status somehow or another. Had it not lost that grandfather status, would your recommendations be different?
Yes,
Okay.
because it would be an older lot of record that,
Right.
on all these older lot of records, they have very similar variances across the county.
It lose its grandfather status through the owner doing anything, or is that through the county doing? I mean, how did it lose its I mean, you went over that briefly, but without.
Well, I would assume it was pursued by the owner. The plat amendment that was done in 2007, I don't know if that was this gentleman or a previous property owner, but it was to amend the front property setback. And that was the only thing that was done, but during that amendment, that's when the grandfather status would have been burned.
The front property setback.
Because on the original plat from 63,
It's a setback.
How did the setback amended to lot?
Yeah, it changed it.
yeah, it changed. The original plat that was recorded in 63, the front setback line was 40 feet. Our county standard is 30 feet, so in 2007, they changed it to 30 feet because whenever you pull a building permit for a structure, it is the county standard or what is recorded on the plat, whichever is greater. So if you have, like our county standards,
Lot size itself did not change.
nothing else changed
Setback changed, and that burned his grandfather status.
because now he's a newer lot of record.
Yep. Okay. Other discussion? Do I hear a motion in regard to 4297 Davis Fairfax?
I'll make a motion. We're going to take these two separate votes, right? It's two-
Well, we'll take it either way, because he's made one application. The staff has made two separate recommendations, so we can take it either way.
All right, I'll go ahead and make a motion that we approve both, based on, one on staff recommendation and one based on this testimony.
I have a motion to approve the variance request for 4297, one based on staff recommendations, and the second based on testimony given. Has he got a second?
I'll second.
Have a motion and a second. Discussion on the motion. No discussion. All in favor vote aye. Aye. Opposition vote no. And the ayes have it. Thank you for coming, sir. Okay, we're going to recess for 10 minutes, and we'll come back at 10 before the hour and take up the last 4 cases. I think there's 4.
5.
5 cases, excuse me. If I can have your attention, please, I'll call the meeting back to order.
Thank you.
Our next case is case 4298, Carol Jean Gregory, requesting 2 dwellings on 1 tract of land. If approved, the applicant will be able to replace one of the existing homes. Applicant is also requesting a variance of 6 feet from the west side yard setback requirement of 10 feet. The existing accessory structure will be 4 feet from the west side property line. The property is located at 2992 Quarry Road, Lot 3, Gregory property. A portion of parcel 65 on Wilson County Tax Map 71 consists of 5.01 acres, zoned R1 residential. We'll get staff recommendations on 4298.
Mr. Chair, the applicant is requesting 2 dwellings on 1 tract of land. On site review, the applicant stated that both homes existed when she purchased the property in the 80s. The variance would allow the applicant to replace the second mobile home on the property. If you look at the aerial, the mobile home that she's looking to replace is the one with the red roof. The white roof structure to the right of that, that is now a stick-built home, I believe. She'll have to correct me if I'm wrong there. If the applicant can show that both homes were on the property prior to zoning, which is 1974, staff can recommend approval. I've got verification that they were there in the 80s. I just don't know if they go back to 74.
Who's here to represent 4298 Gregory? You go, Howard.
Good morning, Carol Gregory, 2992 Quarry Road.
And what would you like to tell the board, ma'am?
My family, my family purchased this property back in 1982. Prior to that time, it had had 2 dwellings on it because it already had 2 septic tanks there. This is a picture from early 90s.
Thank you.
Where we had two houses on the property. My in-laws and my brother-in-law lived next door, and my husband and I raised our family up until March of this year when he passed away.
Maybe you'll take a moment to compose yourself. That's fine.
I'm sorry. So the house, because of his illness, the house is in disrepair, and I really would like to replace it so that I have a safe place to live my life out.
See what I'm going to do. Why don't you have a seat for a moment? Let me take this next case, and we'll bring you back up in a few minutes, okay? All right, I'm going to move to 4299, Fred Rich. We're going to go ahead and take that one up right quick. 4299, Fred Rich is requesting a variance of 5 feet from the east side yard setback requirement of 10 feet. If approved, the proposed garage will be 5 feet from the east side property line. The property is located at 277 Lakeview Circle, Lot 2. Trails End is Group A on parcel 27, Wilson County Tax Map 11K. Consists of 25,700 square feet, is on R1 residential. We'll get staff recommendations now on 4299.
Mr. Chair, the applicant is requesting a variance of 5 feet from the east side yard setback requirement of 10 feet. If approved, the proposed garage will be 5 feet from the east side property line. This is an older tract of record, with the lot being created in October of 1958. Therefore, given the language in the zoning ordinance, staff can recommend approval.
Okay, who's here to represent 4299 Rich?
Doug Myhan, 400 Burris Road, Mount Juliet.
Yes, sir. What would you like to tell the board? Anything?
Yeah, we're needing to, I'm the builder. Melanie owns the house and she asked me to come up here. We're needing to put that garage, they need an extra garage. We built that house last year and theirs is filled up already. Need to put it 5 feet from the property line to make it functionable to where they could use it right without having to make 10 different motions trying to get in and out and in and out. That's why we're trying to do it, just to make it work better.
Does the board have questions for the applicant? If not, does anyone else here wish to address 4299? What am I on, Rich? Yep. No one else? Okay, we'll close public hearing.
If I could ask one more thing, please, sir.
Okay.
We just talked to somebody the other day that's smarter than us, and they said that the surveyor told us not, that we couldn't ask for any variance on the rear property line because it's core. We'd really like to get 5 feet off of it too. It's not drawn on your plot plan, but there's other people that are on or closer than that.
Hold on a minute. Mr. Jennings, he wants to amend his request. It was not advertised as such. What do you think?
I think you could probably do that because the piece of property has been advertised. It'll be as to whether or not Christopher and his folks need to go out there and look at it.
It's against the core. What he's wanting to do is get closer to the core property.
I can address that. I mean, typically, yes, that's not an issue. On the existing recorded plat, there's a 10-foot public utility easement on the rear of all of these properties on the core, which is unique to properties that have frontage on the core. I would say that it's probably not being utilized, but it's still documented on the plats.
Gotcha.
So I would caution you to give a rear setback variance as of right now until if he goes through the plat amendments process.
West.
Okay.
Because of the utility easement that he says is in place at the back.
Yes, sir.
And normally, yes, you can get pretty close to the core. They don't care. We've normally granted those pretty liberally.
Yes, sir.
But if you've got a utility easement back there, that probably needs to be a separate request so that y'all can properly research.
It's not imperative. It would just help their view a little bit if we could go back.
If it's something you feel strongly about, you can make an additional application, but it does need to be vetted because of the utility easement.
Yes, sir. I understand.
I got a question.
Yes, sir. Go right ahead.
Got a question. The proposed garage looks like it's going to be on the back right corner of the property, which is near the lake.
Yeah, if you look real good, you can see a black shed that's been there for ever, right in that vicinity right there.
Are you talking about a garage to hold a vehicle?
A detached garage.
How are you going to get there?
Drive down beside that house. They got 9 feet. He's got an old Corvette he wants to keep in it.
That house is not there anymore. It was torn down and we have a brand new house there now.
Oh, so what we're looking at doesn't even exist?
We tore that house down and built another one back that fit better.
This house doesn't exist?
The one on that picture, right?
I'm talking about the one that was submitted as plot plan.
No, that one, that's what we've got there now.
What you built?
Yes, sir.
Yeah, that's what they built.
Okay, so you've got a driveway that's going to be going up to the garage.
Yeah, it'll kind of take a little veer out. That driveway there is still existing. We didn't tear it out. It's going to just have a little dog leg off of it.
Okay.
He just wants something to keep his daddy's old vet in.
Okay. All right. If the board doesn't have any other questions, does anyone else wish to address 4299 Fred Rich? Okay. If not, I'll close the public hearing on this case and turn to the board. Do I hear a motion, or do we need to have any further discussion on 4299?
I make a motion to approve upon staff recommendation.
I have a motion to approve 4299 based on staff recommendations. Do I have a second?
Second.
I have a motion and a second. Any discussion? And if not, all in favor vote aye. Aye. Opposition vote no. And the ayes have it. Okay.
Great. Thank y'all very much. Right.
Ms. Gregory, you want to come back? Okay.
Yes, sir.
Come right on. All right, we're going back to 4298. I've already read the case. I've heard staff recommendations. Applicant has made comments. Okay. No. So it's your testimony in front of the board that these residences have been here quite some time, going back to the early 70s or beyond?
Yes, sir.
I got you.
Yes, sir.
Does the board have any questions for the applicant? If not, does anyone else wish to address 4298 Gregory? Yes, come forward, please.
My name is Athena Pramatis. I live at 826 Muskogee Way. Dunlop. I had a question from my mom. Does
Address us, please.
sorry. Does this? Because all of us neighbors on Muskogee got a letter about this meeting today. Does this? Because it says it was bordering our property. Does this affect in any way our property?
Let me ask, why did they get a letter? I understand what she said.
Does it push over the next tract of land? Because
Hold on just a minute.
I can explain that.
Yeah.
Yes, ma'am.
Property has been divided, but as of right now, well, it shows it now, but at the time that the letters was sent out, it was all whole. It was one big piece of property.
A larger piece.
That was a larger tract of land. So it's been updated now and divided off to show her 5 acres. If it was like this, when we did the letters, you wouldn't have received one.
So
Thank you, Mr. Fredon. Yes.
way back when, or previously, this was all big one track. If we widened that out, we would see your street. Okay? This property has been cut away, so it no longer borders your property.
Yes, sir.
Correct?
Correct.
Okay.
I appreciate y'all's
And-
time. Thank you.
That's fine. And what she's asking to do is replace what's been there for 50 or 60 years.
Oh yeah. Yeah. My mama knew. Actually, my stepfather actually talked to you at church the other day.
Okay.
So I just had to come. Yes, ma'am. I just had to come here and ask a quick question. I thank y'all for your time. My condolences.
You really want to do that here?
Okay.
Okay. Okay. All right. So, anyone else here wish to address 4298 Gregory? All right. Now, Christopher.
Yes, sir.
Subdivision of property is in play here.
The homes were existing prior to that, and it's still over 5 acres, so I wouldn't have had a way to catch that on the front end. Now, you can consider that, but still the homes were existing prior to the subdivision of property in this instance.
Recommendation stands.
Yes, sir. I mean, we always go off testimony that the 2 homes are there. I don't have a way to trace tax records back that far. She can verify back to 82. It's up to you all to determine the previous 8 years.
If there's no one else here that wishes to address 4298 Gregory, we'll close the public hearing. Appreciate you giving us your comments, and we'll turn to the board now for a discussion or a motion.
Mr. Chairman, I will move that we approve, based on staff recommendation, testimony given, and that the 2 dwellings predates the zoning ordinance.
Have a motion to have a second.
Second.
Have a motion and a second to approve the request. Any further discussion on the motion? If not, all in favor vote aye. Aye. Opposition vote no. The ayes have it. Thank you for coming, ma'am.
Thank you so much.
Okay, our next case is Ray Baker requesting to renew a short-term rental. The board approved the short-term rental for 3 years, February 17th, 2022. Property is located at 531 Hunting Hills Drive, Lot 25A, Hunting Hills, parcel 51.22, on Wilson County Tax Map 77. Consists of 2.92 acres, zoned R1 residential. We'll get staff recommendations now on 4300 Ray Baker.
Mr. Chair, the applicant is requesting to renew and approval for a short-term rental. The short-term rental was initially approved in January of 2021 and was granted its first renewal for 3 years on February 17th of 2022 with the following conditions: that the business plan is part of the approval. The use and amenities of the property have not changed, nor have there been any public complaints about the property to staff's knowledge. Septic records for the property are on file. There's no language in the zoning ordinance granting staff permission to renew short-term rental approvals. However, the board may consider this request. Staff will point out that in renewal cases such as this, if the request is approved, the board has typically granted an extended renewal period. This is one of the first renewals that have went through their three-year renewal. So I don't know if you want to extend that time more, but we will start getting more of these 3-year renewals starting to expire. This is the first case, to my knowledge, that has expired a 3-year renewal.
Got you. Okay. Who's here to represent 4300 Baker?
Ray Baker, 531 Hunting Hills Drive.
Address? Oh, you gave me address. All right. Now, what would you like to tell the board, sir?
Nothing to add. We had a successful first year, and then the last 3 years have been positive and uneventful, so we just want to continue our approval.
Does the board have questions? Yes, sir.
In the package, you say sleeping accommodations up to 6 guests, but you yourself live on the property, right?
We do, yes, sir. We're upstairs.
Does that mean you have 2 bedrooms that you're going to use for Airbnb?
Correct.
You only allow 2 people per bedroom?
Okay. We also have a queen self-inflating air mattress that we offer. Okay.
It's per bedroom.
Okay.
Normally, it's 2 guests per bedroom because of the sewer. I don't know what was granted last time, but I know on here you're saying up to 6 guests, and you could take as many as 8, but actually the limit would be 4.
Okay, yeah, we're happy to amend. That's probably 95% of our bookings anyway.
Okay.
Other questions from the board? And if not, does anyone else wish to address 4300 Ray Baker?
I have a question, and this doesn't pertain to you personally at all. This is just my wanting to understand Airbnb. When y'all are, and if it's inappropriate, somebody tell me, but when y'all are taxed, do y'all pay, are y'all taxed residentially? Do you pay any kind of a business tax, hotel tax, or any of that? That's got nothing to do with you personally.
Yeah,
it's Airbnb in general. Very brief.
It's actually pretty convoluted. So they do provide tax documents, and you report that when you're doing your taxes each year. And then you can report expenses, but all expenses related to the dwelling have to be prorated by the percentage of your home's square footage being used for a short-term rental, and then prorated again by the percentage of days each year the dwelling is occupied. So it as little as we do it, it turns out to be not much.
Regarding you specifically.
No, you do report it, and it's a bit of a convoluted process, but we just roll it into our normal taxes.
Okay. I don't know that cleared anything up for me, but anyway, I shouldn't have brought that up. I was just curious.
I'll say the same thing.
It's not fun to do.
Okay, I think no one else here wishes to address this case. And if not, then I'll close public hearing. And
The only thing that I have to say, and this is just for the applicant, if this is granted and you get a renewal, it would be my recommendation that you come in prior to your variance request being expired. You are over 2 acres, so it doesn't necessarily affect you, but like our most recent amendment to Airbnb was to make it 2 acres across the board, and you are zoned R1. So if your property was just slightly under that, that would have convoluted this issue. So I would recommend coming back in for requests prior to the lapse of your.
Yes. Thank you.
if no one else wishes to speak, we're going to close public hearing, turning to the board for a motion. And I'll make a motion. Go ahead.
I had a question.
Go ahead.
Since he didn't renew before he should have, are we considering this a new Airbnb or extending the terms of the?
My my comments, I looked at it as a new Airbnb to make sure it met all the new regulations that were passed. He still met all those. Now that's up to you whether or not you want to consider it a completely new Airbnb or one that's existing that just didn't come in on time.
What have we done with the ones that have come in the last 6 months?
There was, I think you're 50-50. There was one that had lapsed maybe a couple months. You extended it to a 3-year approval. There was one that had been expired for about, I think, 9 months, and you started over with that one.
And there was one that had been expired in February. I was not here, but they did one in February. It had been expired for 24 months, 26 months.
Yeah, and I believe that one was approved for a 1-year period again. They did not extend that one.
But it didn't comply with the 2-acre rule.
Yeah, okay, that was that.
Cherokee.
Okay, that one didn't I get to no Cherokee that.
In the R2 zoning.
Yeah, that was they approved that. They called that out as a unique situation as being the only Airbnb in the R2 zone district. Was the reasoning for approval of that one, I believe. Starting to dig deep in my archives here.
So I felt like there were circumstances
Yeah.
that there was.
That one was expired.
They don't apply to most that come up here. Part of that being it was R2 zoning.
I think that was the reasoning behind it.
Been expired for over 2 years. That certainly doesn't apply to most people. Okay, but what? How should we address this one? Is this a new application or?
Well, I'm going to tell you, I reviewed it as a new application to make sure it met all of our current standards since he didn't come in prior to his previous request lapsing. If you all want to start the time frame over,
That's what it affects the most, is how long the time frame runs.
Yep.
We've been doing 1 year, 3 year, 5 years, for 3 years.
When did it expire? I'm trying to.
February of this year, it looks like.
February.
February of this year. Yep.
Now, and he's coming in off his 3-year period.
Right.
So the question would be, if we view it as a new application versus an existing, where do you start the time frame at 1 year again, or do you go on to the next step of
I would,
5?
In discussion, I would go on to the next step. I mean, he was just a few months out. That's just my opinion.
Okay. Well, I guess whoever makes the motion can clarify that. So do I have a motion in regard to 4,300? Mr. Baker?
I'm going to make a motion that we approve this, but I'm also going to amend that we start this over as a new one since it has been expired and it's got a 1-year renewal.
Okay. Have a motion to approve 4,300 with all the original stipulations.
Yes, sir.
Okay. For a period of 1 year.
He, Mr. Blades made the request to amend the original stipulations from 6 guests to 4 guests.
And so since we were dealing with 2 bedrooms, we would have a 4-guest limit,
Okay.
correct?
I agree with that, yes, sir. Since
So-
since he's using a bedroom, yes.
So the motion is to approve 4,300 for a period of 1 year. All the original stipulations apply, and he's limited to a total of 4 guests, being 2 per bedroom.
Yes, sir.
Do I have a second?
I'll second.
I have a motion and a second by Mr. Blades. Now, discussion. And if there is no discussion, all in favor vote aye. Aye. Opposition vote no. And the ayes have it. Thank you, sir.
Thank you for your time.
Our next case is 4301. Robert Purcell requesting a variance of 6 feet from the west side yard setback requirement of 15 feet. The existing house is 9 feet from the west side property line. The variance is needed in order for the applicant to be able to divide the property. The property is located at 1150 Pile Grove Road, Lot 33, Mack Hall Farm, parcel 5.33 on Wilson County Tax Map 56. The property will consist of 1.66 acres and is zoned R1 residential. We get staff recommendations now on 4301.
Mr. Chair, the applicant is requesting a variance of 6 feet from the west side yard setback requirement of 15 feet for a proposed lot to be created. The variance will allow the existing home to be 9 feet from the newly created property line. The subdivision will create 2 new lots of records if the variance is granted, voiding the existing plat from May of 1974. This would appear to have little adverse effect, but this would be a self-created hardship. Therefore, staff cannot recommend approval. The lots in question that they're creating are going to meet all other minimum requirements for a single-family lot. Just the existing home would be would need to be 9 feet from the newly created property line.
I thought we were working on a July of 74 adoption date on the zoning ordinance, and this says the plat was from May of 74. So wouldn't that predate the ordinance?
It would, yes, sir. But he's looking to create new lots. He's not asking, I'm not gonna allow a variance on a newly created lot because his lot pre-exists. Because he's looking to take a lot from 1974 and turn it into 2 brand-new lots.
Gonna subdivide.
Yeah.
Correct.
He's asking for a setback on a property line that does not exist.
Got you. Okay.
Does that clarify that? Sorry.
That's fine. All right, who's here to represent 4301 Purcell?
Robert Purcell, 1150 Powell Grove Road.
All right. And what would you like to tell the board, sir?
Want to make it possible for my son to build his house behind my house.
That's 6 feet from the west side yard setback from 15 feet. Okay. Does the board have any questions for the applicant? So this would be your house here on this plat, and this new property line would be running down here, creating his 50 foot to get back to his lot. And your house is too close, so you can't meet 50 foot and meet the setback line. Correct? Gotcha. Okay. Questions for the applicant from the board?
So they're taking 50 foot off the left-hand side of this lot and putting it with a lot in the rear.
This is the lot. This is the lot.
Yes, sir.
Original, like it exists today.
They're taking 50 foot away from this lot to give to this lot.
Yes, so this is the way it exists today. This is the 50 foot going to this lot, but his is his
I
house.
understand that.
So
What's the access to this lot currently? Before you give 50 foot, how do you access this lot?
It's part of the home
not a
lot.
lot.
It's not a lot.
Okay, I'm with you. Now he's gonna create a new lot in the back.
yeah, this is all one is today.
Okay.
And when he puts the 50 foot in, then we've got,
I'm with you. I'm with you.
I'm trying to see what that is between the, 6 feet.
You can't put the 50 foot on the other side because of your soils area. Would that be correct?
I believe that's.
Well,
Putting it on the,
that's one of the considerations. The soils areas on there. You actually, the way the house is laid on there, it would almost be an identical variance request.
it's the house is centered then.
Yes, sir.
I got you.
In addition, there's an existing deck and the HVAC unit on the east side of the existing house.
Okay. Anyone else here wish to address 4301 Purcell? Yeah. If y'all would step aside, let's let these other folks come forward.
I'm Judy Cox, and I live at 1704 Blairmont Drive. The lot on to the west side of their property is the vacant lot. If you go down Powell Grove Road, it's the only land that's left on Powell Grove Road. All those tracts are 5+ acres down through there. And if you notice, they all have one house, and they all have at least 5 acres. And my parents bought that 5 acres in 1981. And so my parents have passed away now, and the heirs own the lot. And if the vacant lot. It's the only vacant land on that whole road. But everything else on that whole road is 5 acres plus with one house. And they're wanting to put another house, so that land next door is going to have 2 houses on it with all 5 acre tracts around it with 1.5 acres on a house. So we don't want that land split up to keep the 5 acres all down Powell Grove Road like they are right now. And then we would have to have the variance. That house would be that close to our property line going down it. So we request to deny.
Thank you, ma'am. Yes,
Hello
sir.
there. Good morning. My name is Charles Reeves. I live at 1220 Powell Grove Road, which is next to the lot, the vacant lot, which I'm married to my wife. She's a partaker of that land. I'm a caretaker of the land. I take care of it. I take care of the fence, the property, and everything. I bought that property, my property there, at the day of the sale, and you're only supposed to have one house on the property, and it had to meet all the restrictions which we applied when we bought the property. And all the 5-acre tracts have always been like that. And it's kind of surprised me that they were trying to build another house on there when it's only made for one. Because when we had to perk our land, it took quite a bit to get that, approved. You know what I'm saying? So that land, I don't think could perk that much. You know what I'm saying? So I like to keep it that way, and I wanted to keep the property that way. We kept it for all these years, and it should be kept that way because that's the way it was sold to us, and that's the way we wanted to keep it. So I'm denied.
Thank you.
Thank you.
Yes, sir.
I do. My name's James Cummins. I'd just like to say that all this land here is 5 acres to 10 acres or up is based on one house. And the whole community has been that way, one house. And now this one property here wants to add another house on the 5 acres and making it more like a subdivision now. Anyway, we'd like to keep it as is, so that's all I got to say.
Thanks, sir.
Thank you.
Anyone else? Okay. If not, I'll close public hearing on 4301 Purcell and turn to the board for discussion or a motion.
Mr. Chairman, I will make a motion that we deny case 4301 based on staff recommendation.
I have a motion to deny 4301 based on staff recommendation. Do I have a second?
Second.
I have a motion and a second. Discussion on the motion. If not, all in favor vote aye. Aye. Opposition vote no. And the ayes have it. Thank all you people for coming. Thank you. Okay. Our next case is 4302. Connor McChurch requesting a variance of 6 feet 11 inches from the height requirement of 22 feet. If approved, the proposed accessory structure will be 28 feet in height. 28 feet 11 inches in height. The property is located at 1605 Jackson Road, parcel 31.01, Wilson County Tax Map 117, consists of 9.43 acres and is zoned R1 residential. We have staff recommendations on 4302.
Mr. Chair, the applicant is requesting a variance of 6 feet and 11 inches from the height requirement of 22 feet to allow an accessory structure to be 28 feet 11 inches. Given the language in the zoning ordinance, staff cannot recommend approval of the height variance.
Okay. Who's here to represent 4302 McChurch?
Morning. Connor McChurch, 1605 Jackson Road, Mount Juliet.
And anything you'd like to tell the board, sir?
Yes. First off, if I can just have it noted, after the submittal, I contacted the distributor of this accessory structure, and he was able to clarify removing the cupolas from the top would actually put it more so at 27. It's a 2-foot cupola. So I'd just like that, to note that, because based on the renderings that I've submitted, it was the aforementioned height. And so, of course, I'm amenable to the cupolas. I'm indifferent to those going on. A couple considerations I'd just like to voice. Lot size, I believe it's 9.43 acres. It's got roughly a half-acre pond on it. So all in all, little bit above 9.43. The location, everything that you see here on Jackson Road facing west is family land. So to the north of me is Freeman Savage. To the south of me is my wife's cousin. To the south of them is another cousin. And to the south of them is aunts and uncles. And so this whole side here is family land. I will say also to the north of Freeman Savage is Randy Savage. So again, this is dynamic to this tract here is that it's all family land. Therefore, there's no opposition from neighbors. You can't see it because it's not scaled back, but on the back of the property, there's no other property until you get to Sanders Lane. So there's acres upon acres upon acres without, another dwelling. Second consideration, obviously the use case is personal. I've got a fifth wheel camper. It's pretty tall. I've had to get a custom size garage door to get this thing in. Got a tractor, just some more personal use stuff for that. Aesthetics, I will mention the aesthetics. So the plans that I've submitted, the roof pitch does match the main house. I've got a 612. I've got some secondary pitches that are 512, but our main house is 612. Also, with the aesthetics, we can incorporate some brick into it. There's some posts up front that wrap around, and we're gonna brick, a third of the way up on those. But as far as the plans, this is going to be a metal shop. Color will be the same as the house. It's a white house. It's got black accents and wood accents. So aesthetically, it's gonna match. Last consideration is there is a financial burden here. The company that I'm working with, and I'll just put this diplomatically, it was just a little bit of an oversight when we sat down. This is a custom scaled shop, and so we kind of went through this process on the front end, paid all the fees. It's custom, so they tack on those fees, and then only to find out that the individual wasn't as well versed as he needed to be in the height restrictions of our particular county. So it's put me in a little bit of a financial hardship. I have called them to try to see if there's any wiggle room, because at this point they're going to assess a $5,000 fee for a change order, and it's more than a minimum because of the height and the roof pitch and all that.
But they made the mistake.
Correct, but it was executed, and it in the agreement they have no liability towards this.
Not something we can consider.
Understand.
But I'm just curious. You're almost as tall from the plate to the ridge as you are from the ground to the plate. What do you do up in all that space?
You're talking about just where the trusses are?
I mean, yeah, from the plate up is 12 feet. What do you do up in all that open space up there?
Well, the interior is 16.
Yeah, I said almost.
Interior 16, yeah.
From the plate to the ridge as you are, or the top of the cupola.
Yeah.
As you are from the ground to the plate. I just wonder why. I mean, that's pretty expensive to do all that. You You have an apartment up there?
No,
No?
no.
Matching the roof pitch on the house.
It's matching that roof pitch on that house. And it's because it's deep. It's a 48 deep, I believe is what it has on there. So if you just do a 612, you know,
According to your drawing, though, you can't hardly see the house from the shop. Well, I mean, it's way back there in the woods.
well, correct. Only because you've got a pretty good thicket of trees right there. Correct. And that was the intention, you know, obviously to not build this thing front and center, obviously, but no, nothing above this 16 feet. It's all just trusses and whatever insulation they're going to put on the roof.
Does the board have any questions for the applicant? Yes, sir.
What size building is it? I don't see anything written down.
This is it's a 48 deep, 64 long.
48, 64?
Yes.
Chris, is that allowed on that property?
Yeah, we don't have a size minimum when there's a primary residence on the home.
Okay.
The size restriction comes in when it's the sole use on the property.
How big did you say it was?
4864.
Yeah, 48, 64, and it's we got the height at 16 inside.
Oh.
Yeah.
Okay. Any other questions for the applicant?
It's just north of 3,000 square feet if you're trying to do the math.
Just a little bit up, yeah.
Wondering if 48 by 64, it's almost as tall as it is long or wide. It doesn't make any difference. It's not, not relevant. Okay. Any other questions for the applicant? I don't think
You
there's-
have amended your request from 6 foot 11 inches down to 5 foot. Would that be correct?
Yes.
I just want to clarify that.
Yes.
Okay. And I guess there's no one here who wants to address this because there's no one else here. And sort of answers that question. Okay, so the public hearing is closed, and do I hear a motion from the board?
Mr. Chairman, we have a lot of these, and I know we have some heated discussions over these.
Not on my part. I know how I'm going to vote.
I on a lot this size, this far away from the property lines, I see no harm whatsoever in allowing it, but that's just my opinion. I mean, this is a 9-10 acre lot, and he's 100, 200, 600 feet. He got how far away he is from property lines, and so
there you are making law again.
I'm not making a law.
We're not making law. We're interpreting.
All
right. In regard to 4302, do I hear a motion?
I'll make a motion to approve it.
Have a motion to approve 4302. I have a second?
Second.
I have a second by Mr. Neal. Any discussion? If not, all in favor vote aye.
Aye.
Opposition vote no, and I vote no. I have 2 noes. Just 2 noes. Got 3 yeses, so you're approved. All right. Anything else, Mr. Christopher?
No, sir, I do not have any further discussion this month.
Okay. And Karen, do you have anything else for us?
No.
All right. Then we are adjourned.